The first sign that something was wrong was not the missing money, it was the email. At 6:14 a.m., Olivia Grant opened her laptop in her San Diego apartment and found a message sent from her own account to every major client her design firm depended on. The subject line read, "Payment dispute and internal misconduct." She had never written it. By 6:19, 3 clients had already replied. One asked whether her company was falling apart. Another demanded an explanation for the fraud allegations. The third simply canceled a contract worth nearly $80,000. And then Olivia saw the transfer. $42,000 had been moved out of the business operating account overnight. Not to a vendor, not to payroll, to a digital wallet she did not recognize. Her hands went cold because she already knew who had done it. David Cross had once sat just 10 feet away from her. He had managed back-end systems, passwords, scheduling platforms, and client access when the company was still small enough to run on trust and caffeine. He knew where everything was. He knew how she worked. He knew Olivia was still using an old recovery email she had meant to change for months. And 3 weeks earlier, Olivia had fired him. Not dramatically, not publicly. She had done it in a glass conference room, with the blinds half drawn and a folder prepared in advance. David had smiled through the meeting in a way that unsettled her more than anger would have. "So that's it?" he had said. "5 years, and I'm disposable?" "It's final," Olivia told him. "You'll receive severance. Your system access ends today." But his access had not ended that day. Not completely. By noon, Olivia was sitting across from attorney Alex Reeves in a downtown office overlooking the courthouse. He was calm in the way experienced litigators often were. Never rushed, never theatrical, already thinking 3 moves ahead. "Tell me exactly what he had access to," Alex said. "Email systems, client folders, scheduling platforms, invoicing tools." "Not banking directly," Olivia said. "At least not officially." "Officially," Alex repeated. She slid her laptop toward him. "He knew my habits. Recovery links, password patterns, security questions. He didn't need official access if he knew how to get around the door." Alex read silently for a moment, then leaned back. "This is more than a workplace grudge," he said. "If he knowingly accessed your systems without permission, copied or used your data, and caused financial loss, California gives us more than a criminal complaint. We can sue." Olivia stared at him. "Even if the police get involved?" "Especially then," he said. "Criminal law punishes. Civil law repairs." That sentence stayed with her. By the end of the day, Alex had already sought emergency relief in civil court. He requested a temporary restraining order to stop David from accessing any company systems, contacting clients through impersonated channels, or moving any more digital assets tied to the breach. He also prepared a complaint seeking damages for the stolen funds, forensic investigation costs, reputational harm, and attorney's fees. The following week, the courthouse felt colder than Olivia had expected. David arrived in a dark suit that made him look cleaner, steadier, almost innocent. His attorney stood beside him, and he carried himself like a man who believed intelligence could substitute for morality. When his eyes met Olivia's, he did not look ashamed. He looked offended. Inside the courtroom, the hearing moved quickly. Alex opened with precision. "Your Honor, this is not speculation," he said. "We have logins from devices linked to the defendant, recovery email reroutes, initiated after his termination, unauthorized communications sent to clients, and a transfer of company funds after access was obtained without permission." David's attorney stood immediately. "My client had prior authorization to use those systems as an employee." The plaintiff is trying to turn a workplace dispute into a dramatic accusation because her company is unstable. Alex did not react. Prior authorization ended when employment ended. What happened after that was not work. It was intrusion. Then the forensic expert took the stand. She testified that someone had accessed the company's email environment late at night, using credentials recovered through a backup email that had been altered just hours earlier. The IP history matched locations associated with David's home network and mobile device. Deleted forwarding rules had been restored during the investigation. Client communications had been exported. The login traces also showed deliberate efforts to conceal the activity. David's attorney tried to soften the damage. Could someone else have used those devices? It is theoretically possible, the expert said. In the same way, it is theoretically possible that a burglar also borrowed the homeowner's keys, alarm code, and phone before breaking in. Even the judge paused at that. But the most damaging testimony came from Olivia. She did not cry. She did not perform outrage. She explained what the breach had actually done. One client left within hours, she said. Another froze payment. We had to lock down systems across the company and hire outside specialists. Staff couldn't work normally for days. Every conversation became about whether we had been compromised. It wasn't just money, it was trust. Why do you believe Mr. Cross did this? Her attorney asked. Olivia turned toward the defense table. Because he knew exactly where to hurt me without breaking a window. That line landed hard. When David finally testified, he tried a different strategy. He admitted he had checked the systems, but denied acting with malicious intent. I was trying to preserve records, he said. I believed Olivia was pushing me out unfairly. I wanted proof of internal misconduct. The judge leaned forward. Did you have permission to access those systems after your termination? David hesitated. No. Did you send emails from Miss Grant's account? I sent messages clients deserved to see. Did you move company funds? I transferred money. I believed I was owed. The courtroom went silent. Not because he had denied it. Because he had just admitted the parts that mattered most. At trial, Alex narrowed the entire civil case down to one simple theme. You do not get to break into someone's digital house just because you feel wronged. He walked the jury through the timeline. Termination. Recovery email change. Unauthorized login. Client messages. Data export. Fund transfer. Forensic costs. Lost revenue. Emergency containment. Legal response. Then he gave them the number. The stolen funds. The documented business interruption. The cost of digital forensics. And the lost contract pushed the damages far beyond the original transfer. The breach had spread like fire through contracts, reputation, and operations. The defense leaned on emotion. They portrayed David as a resentful employee who made reckless decisions during a humiliating separation. They insisted Olivia's losses were exaggerated. They called the canceled client a business decision, not a consequence, but by then the evidence was too mechanical to romanticize. The timestamps did not care about wounded pride. The access logs did not care about resentment, and the money trail was devastatingly clear. When the verdict came, Olivia kept both hands folded in her lap. The jury found David liable. The judge entered a civil judgment awarding compensatory damages for the financial loss and for the costs Olivia had reasonably incurred to investigate and contain the breach. The court also issued injunctive relief, barring David from accessing, contacting, or interfering with any company systems or accounts. Then came the final blow, because the conduct was found to be willful. The court allowed additional financial consequences that turned David's act of revenge into a long-term debt. Outside the courthouse, reporters waited by the steps under the pale California sun. David kept his head down. Olivia did not smile. Victory had been too expensive for that. Alex stood beside her and said quietly, he thought hacking would give him control. Civil court turned it into accountability. That night, Olivia changed every password, every recovery method, every habit built during the early years, when trust had been cheap. She sat alone in the office, long after everyone else had left, listening to the hum of servers, air vents and fluorescent lights. What David had stolen was not just data. He had stolen the illusion that modern harm has to look physical before people take it seriously. But the law had seen it, and that mattered, because in California, unauthorized access to computer systems is not just a tech problem or a workplace argument. Under California Penal Code Section 502, it can trigger serious consequences when someone knowingly accesses systems without permission, uses data, disrupts services, or causes loss. And just as importantly, the victim is not limited to hoping the state takes action. The law also allows a civil lawsuit for compensatory damages, injunctive relief, attorney's fees, and, in the right case, even punitive damages. That is the real lesson here. Anger does not become lawful just because it travels through a keyboard instead of a crowbar. In the digital world, revenge still leaves fingerprints, and when those fingerprints cost someone their money, their clients, and their peace of mind, civil law can do what revenge never can. Measure the damage, stop the harm, and force the person responsible to pay for what they chose to break.